All right, the court is calling 2021 CR 2505, State of Texas versus OTIS TOUSSAINT. Can I have parties announced for the record for the state?
Michael Villarreal and Michelle Hayden for the state.
For the defense?
Shannon Locke and Kim Gonzalez for the defense.
All right, the court received a text message. I've informed both parties that they could text the court if there's some kind of late matters, issues after hours that need to be taken up in the morning so that we won't keep the jury waiting. I did receive a text message from Mr. Locke. Mr. Villarreal, you're included in that text message, is that correct?
That is correct.
And Mr. Locke requested that the motion in limine, or he stated that the motion in limine he felt needed to be heard before opening statements and before the jury were brought in. So state, have you had a chance to review the defense's motion in limine?
I have, Your Honor.
All right, defense.
Well, Your Honor, a couple things. One, we're asking that any prior bad acts alleged by the state or by its witnesses, that those be excluded from evidence. More than just 404B, Your Honor, there is a specific problem with trying this kind of case and bringing in prior bad acts or prior allegations.
What bad acts are you speaking of?
So throughout the state's discovery, there's allegations. There's allegations of abuse. Obviously, we don't believe that any of that is relevant for this kind of case.
All right, state, with regards to any allegations of abuse, are you planning on presenting that to the jury?
At this time, I don't plan on presenting within my case in chief. That obviously might change depending on cross-examination and if the defense offers any evidence of their own.
All right, at that state, if you plan on questioning any witness with regards to that, I'm going to ask that you approach before you do that.
Yes, Your Honor.
Next.
Additionally, Your Honor, what we're concerned with is the state has indicted Mr. TOUSSAINT very narrowly. They have indicted him for taking and retaining the child on January 2nd, 2020. In the state's disclosure, there's allegations that he withheld the child from for a year. There's allegations that the mom hasn't seen the child for a year. None of those are relevant to whether or not Mr. TOUSSAINT took and retained the child on January 2nd, 2020.
Is it on or about January 2nd?
It is on or about, but it's not a continuing course of conduct. And so the problem is, in the indictment, there's no actual notice to us as to what provisions of which order he violated. It just says a Court of Appeals order from Nashville, Tennessee, and a Missouri Circuit Court order. That's all it says. And so the only notice that we have is the January 2nd date. So
All right, state.
Your Honor, it's obviously relevant when he took the child, when he retained the child. So all of that evidence is part of this case, and it's necessary for the state's evidence to prove when he took the child, when the mother would have seen the child, when the child was returned to the mother, because otherwise the jury is unable to determine whether he violated that order, and particularly his retention of the child, even if it is an extraneous offenses, those are relevant to show his motive, to show his state of mind, whether he intentionally or knowingly committed.
All right, defense, that'll be overruled, and you can make an objection at the time if you wish to make an objection at the time, but based upon the proffer from the state, that objection or that request for a motion in limine will be overruled.
And specifically, Your Honor, what we would argue, and what we are arguing, is that allowing additional evidence in essentially is a constructive amendment of the indictment and a violation of Mr. TOUSSAINT's fundamental right to be indicted by a grand jury. And so if the state amends its indictment with its evidence, and by introducing other acts, essentially other potential violations of the court orders, we would argue, and we are arguing that introduction of evidence is a constructive amendment of the indictment, which we are objecting to.
All right, that'll be overruled. Are both sides ready to proceed?
She's ready.
That's ready, Your Honor.
All right, let's bring the jurors in. It feels like it's a Monday, even though,
This week has been kind of slow.
yeah, it feels like a Monday, even though it's Wednesday. You know, it moved quickly, right?
Yeah.
Because I can't believe
It's a
it's,
good Monday.
yeah, I can't believe it's already Wednesday. Okay, Brenda, I just received notice that there's a fitness class scheduled. I'm going to make sure I go to at least 3 of these.
Here at the county,
Yes.
which one is,
Well, they have yoga, which I haven't tried,
yeah,
but I think stretching is so important.
yeah.
And then they have muscle endurance and boxing. I may try my hand at boxing. Don't tell my mom.
Get cardio.
All right, jury. Oh, please be seated. We stand for you. And please feel free to grab the pillows because I know those seats are uncomfortable. I've been working on that to make sure that we get pillows for everyone. All right, everyone, please be seated. All right, ladies and gentlemen, I know we said we would start at 9 a.m. It's now 9:11 a.m. I had to take up some matters outside your presence. I'm also presiding judge this week. So I receive a lot of documents from other courts that I have to take care of. And again, you're going to notice people who are coming from the back door. You may see some officers who are coming from the back, but those are not people who are involved in this case in any way. It's for other courts and other issues I have to take up. So whenever you see someone coming through the back door, just do your best to ignore that because it has absolutely nothing to do with this case. Was everybody able to find decent parking? Hopefully not too expensive. I'm sorry about that. All right, if all of you, I know you've been sworn in downstairs, but if you could raise your right hand for me, I'm going to give you the oath as it relates to this specific case. Do you and each of you solemnly swear or affirm in the case of the state of Texas against the defendant OTIS TOUSSAINT, you will a true verdict render according to the law and the evidence, so help you God? All right, you can lower your hand. And remember, if there's something that you cannot hear, just let us know so we can turn up the microphones. All right. And if anyone needs a break, just raise your hand. State?
Is your man proceed with reading the indictment?
Yes. Defense?
True bill of indictment. In the name and by the authority of the state of Texas, the grand jury of Bexar County, state of Texas, duly organized and paneled and sworn as such at the March term AD 2021 of the 175th Judicial District Court of said county in said court at said term do present and to said court that in the county and state aforesaid and interior to the presentment of this indictment, paragraph A, on or about the 2nd day of January 2020, OTIS Earl George TOUSSAINT, hereinafter referred to as defendant, did intentionally and knowingly take and retain Omari TOUSSAINT, a child younger than 18 years of age, knowing that the taking and retention violated the express terms of a judgment and court order disposing of the child's custody, to wit, 19th Judicial Circuit Court, Cole County, Missouri. Paragraph B, on or about the 2nd day of January 2020, OTIS Earl George TOUSSAINT, hereinafter referred to as defendant, did intentionally and knowingly take and retain Omari Toussaint, a child younger than 18 years of age, knowing that the taking and retention violated the express terms of a judgment and order of a court disposing of the child's custody, to it, the Court of Appeals of Tennessee at Nashville, against the peace and dignity of the state, signed four men of the grand jury.
Mr. Toussaint, to paragraph A, how do you plead guilty, not guilty, or no contest?
Not guilty, Your Honor.
To paragraph B, how do you plead guilty, not guilty, or no contest?
Not guilty, Your Honor.
All right, thank you. You can be seated. State, do you have opening statements?
We do, Your Honor.
You may proceed.
Good morning, ladies and gentlemen. This is not a case where a parent inadvertently missed the third Friday of the month. This is a case where a mother, Sharita Golden Lee, did not see her child, Omari Toussaint, for over a year because of the actions of the defendant. Now, this case has a complicated procedural history, and you're going to hear from one of the civil attorneys involved in this case, Michelle Machoto, who's going to help break down that history and go over some of the orders and judgments in that case and help explain those to you. But the incident in question and the one that we have to prove to you, that on or about January 2nd, 2020 in Bexar County, Texas, the defendant took and retained custody of Omari Toussaint in violation of court order. That's not complicated. So the short story of what you're going to hear is that in 2011, a Missouri court entered a custody order for Omari Toussaint, the child of Sharita Golden Lee and the defendant. Per the terms of that order, Sharita Lee had primary custody of Omari Toussaint during the school year. Defendant had custody of Omari Toussaint during the summer. And for purposes of our case, defendant had custody on New Year's Eve of odd numbers years of Omari Toussaint and New Year's Day on even numbered years. And on January 2nd, in even numbered years, Sharita was to regain custody of Omari again. Omari went back to her on January 2nd. Now, between the entry of the original Missouri order and the offense date of January 2nd, 2020, there are a number of events that take place, and you'll hear about that in trial. There's litigation between Sharita Lee and OTIS Toussaint. And Sharita and her attorney will explain that to you. Both Sharita and the defendant moved to Tennessee after Missouri. And in Tennessee, there's an invalid order regarding custody entered, which Sharita had no knowledge of at the time of its entry. And on October 2018, the defendant took their child, Omari Toussaint, from his school in Tennessee without Sharita's consent or knowledge. He took him to Germany where they lived, and thereafter moved him to Texas without telling Sharita. Sharita only found out that the defendant had moved to Texas with their child by happenstance. She received a piece of mail indicating the defendant had been served at his new address in Selma, Texas. So on January 1st, 2020, Sharita Lee traveled from Memphis, Tennessee to San Antonio, Texas in hopes of being rightfully reunited with her son. You're going to hear from the Selma Police Department, who sought to help Sharita regain custody of their son. The officers will tell you how they went to the defendant's residence at 8139 Elliston Boulevard in Selma to contact the defendant. They tried to contact him on January 1st, January 2nd, and January 3rd. His vehicle's in the driveway. He's got a Ring doorbell. He did not answer the door, did not answer phone calls, and did not give away Omari Toussaint as he was supposed to under the orders. And on January 3rd, 2020, after no contact with the defendant or their son, Sharita had to return to Tennessee empty-handed without her child, after not having seen him for over a year. Now, on January 2nd, 2020, when the defendant did not turn over Omari Toussaint, he knew the original Missouri order was legal and binding. A Tennessee court had vacated the invalid Tennessee order. Further, defendant actually registered the Missouri order in Texas on November 25th, 2019, indicating he knew the Missouri order was the valid order and that they were to follow the terms of that order. You're going to hear from Sharita Golden Lee herself about what she went through, about how she didn't see her child, And about how she travels to Texas only to go home alone and empty-handed. And while not turning over a child on a certain date may not be a big deal if you've actually been abiding by the terms of a custody agreement until that point, it is a huge deal when you've kept your child away from their mother for over a year. The mother does not know where you're living, and when she finally finds you, you still do not get to see your son. And at the conclusion of all the evidence, we ask that you return a verdict of guilty. Thank you.
Defense.
Good morning, ladies and gentlemen. You're going to hear a story of a child custody battle that spans 3 states. It's a child custody battle that is very complicated. And on January 2nd, 2020, Mr. Otis TOUSSAINT finds himself in a gray area. Why does he find himself in a gray area? That's going to be the question. And the question in front of you today is whether or not Otis TOUSSAINT knowingly and intentionally violated a court order. And the question behind that is what court order is valid? And at that point, there is no court order that is valid. All of the court orders have been litigated and invalidated. And what Mr. TOUSSAINT is trying to do is he's trying to get court orders in place so that visitation can be established and a normal life can be had between all 3 of the parties, Otis, Omari, and Sharita. So what happens? In Tennessee, okay, there was the 2011 Missouri court order. Okay, that order was changed by the agreement of the parties, and that order, when it was changed, was appealed by Sharita Lee to a National Court of Appeals. That National Court of Appeals overturned the agreement that the parties had made, and so there was no date that it was actually entered, and because there's no date that it was actually entered, it can't have any effect. Okay, so we're going to vacate that order. They didn't invalidate it. It's an important distinction, the difference between vacating something and invalidating it. And when you hear from Mr. TOUSSAINT's lawyers, you're going to hear why that distinction is important. But when the National Court of Appeals vacated that order, they said, this is what we're going to do. Okay, we're going to keep the status quo. Okay, and at that point, Omari was living with Otis. We're keeping the status quo. Okay, and we're going to remand this to Shelby County, where Sharita was living. We're going to remand it to Shelby County, okay, so that they can make decisions about what's appropriate. And that never happens. Okay, so the state has alleged 2 things. The state has alleged the violation of a Tennessee Court of Appeals order. Okay, the weird thing is the Tennessee Courts of Appeals don't tell people to do that. Okay, in the structure of our court environment, the appellate system tells other courts to do things. Okay, so the way that it works, and you'll hear this from Otis's lawyers, a trial court makes decisions and people have to live by those decisions. And then the people that those orders are then appealed to appellate courts. And the appellate court says, okay, correct these orders. And that's what they did. They said, correct these orders, but while you're correcting them, maintain the status quo. So Otis is living by that. He's maintaining the status quo, which is Omari is living with him. So when Sharita Lee shows up on January 2nd, 2020, and says, give me back my child, Otis does what anybody would do. He calls his lawyer. And you're going to hear his lawyer. His lawyer is going to say, there's no valid order in place right now. You're living with Omari in Texas. And because there's no valid order in place, you don't have to give him back. You have to maintain the status quo. That's what the Tennessee Court of Appeals said. And so he doesn't give them back. He relies on the advice of his lawyers. And as he's relying on the advice of his lawyers, he's not knowingly or intentionally violating anything. What he is doing, though, is with his lawyers, he's trying to register these other orders so that they can have orders moving forward. Okay, you'll look at the Missouri orders that govern this child custody, and one of the things is that it is absolutely unenforceable. One, it is completely vague, and when the state says that you have to treat the child on January 2nd, nowhere in the order does it say that. It doesn't say that anywhere. It says during the school year, Sharita, okay, is the primary custodian, but it doesn't say that Otis can't have access, and it doesn't say when the school year begins. School years don't usually begin on January 2nd. That's usually Christmas break. It is a completely vague order and unenforceable. Additionally, the child, if the Missouri order is supposed to be followed, the child would have to be exchanged at a police station in Missouri where none of the parties live. So this order is just completely invalid. So what OTIS does is he says, look, let's go back to that 2010 order, but let's modify. And they're in that process when this case happens. So they're in the process of registering a foreign order, Missouri order, okay? Registering that order and modifying. And as they're doing that, Sharita is claiming that he's violating. OTIS TOUSSAINT never intentionally or knowingly violated a court order. He did not do that. He is not a felon. He's somebody who plays by the book. And as he was playing by the book, he was doing his best to follow the court order as he understood it, follow his lawyer's advice. And the state is bringing the charge. I told you at the beginning of this case that it is our honor and privilege to represent him. He has served our country, and now we're using the rights that he served our country for. We're using those rights to defend. At the end of this case, I'll ask that you find it not guilty.
All right, state, call your first witness.
Yes, sir. At this time, state calls Michelle and Show. Your Honor, before we do that, state would invoke the rule.
The rule has been invoked. All right, Brennan. All right, could you raise your right hand for me, please? Do you solemnly swear from the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. State your name for the record.
Michelle Michaud, MICIOTTO.
State.
Thank you, Your Honor. Ms. Michotto, what do you do for a living?
I am an attorney.
Okay. And when did you become licensed?
First in Texas in 2004, but I'm also licensed in New York and in Bexar counties.
So prior to being a lawyer in Texas, were you lawyers in both of those locations?
I was.
As far as your practice is concerned here in Texas, in particular, in around the time of 2020 and 2021, what were your areas of practice?
During that time, I was practicing primarily family law.
Since then, have you expanded your practice?
I'm doing more business litigation now, but I've been practicing almost exclusively family law since about 2008.
Do you know a person by the name of Sharita Golden?
I do.
And how do you know her?
She is my client in family law proceeding in their county.
Okay. And have you represented her here in Bear County?
I have.
And particularly in civil courts in Bear County?
Yes.
Do you recall when you first met Sharita? What year?
I believe it was in the early part of 2020.
And in representing Sharita, was part of your job going through and looking at court orders, filings, and things like that in order to adequately represent her?
Yes.
And in particular, what specifically did you represent Sharita in?
I represented her in multiple suits in Bear County, family law proceedings, I believe that there have been 4 different proceedings in their county.
And in representing Sharita, is it fair to say those things that you represented her in related to the possession of her son, Omar?
Yes, that's
In your representation of her, have you been able to review documents from Missouri and Tennessee and Texas that relate to the possession of Omar Toussaint?
I have.
And is it fair to say that you're familiar with these documents?
Yes, I am.
Is it fair to say that you're familiar with the history of the orders that relate to the possession of Omar Toussaint?
I am.
Your Honor, may I approach?
Yes.
Ms. Machado, I'm going to show you what has been marked as State's Exhibits 1, 2, 3, and 4.
Okay.
I correct the record to say 1, 2, 3, 4, and 5.
Okay.
Are you familiar with those documents?
I am.
And have you reviewed them previously?
I have.
Um, As it relates to State's Exhibit number 1, specifically, what is State's Exhibit number 1? Without telling you the contents necessarily, but generally.
Okay, it is an order concerning the child issued out of the state of Missouri, the final order about custody, possession, and child support related to the child.
And the first page contains an authentication of the judicial records and proceedings, correct?
Yes,
As it relates to State's Exhibits numbers 2 and 3. Are those also orders related to the possession of Omar Toussaint?
well, exhibit 2 is not an order because it was vacated, but, yes, it was a document that at one time was an order about the child.
And both of those are out of Tennessee, correct?
Correct.
And then finally, State's Exhibits numbers 4 and 5. Are those orders out of, or documents and filings related to cases here in Bear County that relate to the possession of Omar Toussaint?
Yes,
Okay. And if you go look at the last page of both of those, is it fair to say both of those are certified copies?
yes,
Your Honor, at this time, the state would move to admit State's Exhibits 1, 2, 3, 4, and 5, tendering to defense for inspection and would be previously tendered. to discovery.
Any objections?
No, he's in the.
Yes.
Madam Clerk, Your Honor?
Yes. All right, states exhibits 1, 2, 3, 4, and 5 are admitted into evidence.
And Your Honor, may I publish and work in the law, that's what I work with these documents.
Yes.
Thank you, Judge. All right, so I'm going to show you what's been admitted in states exhibit number 1. Specifically,
You should be able to see it on your screen.
as it relates to state exhibit number 1, is it fair to say that this order is an order out of the 19th Judicial Circuit Court of Cole County, Missouri?
Yes, that's correct.
Okay. And as it relates to the orders, you've previously reviewed this, correct?
I have,
And you've reviewed this in your representation of Ms. Sharito Golden.
I have.
I want to move to page particular. But item number 14. Item number 14 directly relates to the possession of Amari Toussaint around certain holidays, correct?
Correct.
Okay. And in particular, it says at the bottom, the child will be with the plaintiff on New Year's Eve in odd numbered years and New Year's Day in even numbered years, and with the defendant on New Year's Eve in even numbered years and New Year's Day in odd numbered years. Is that correct?
That's correct.
Particular. And I should say the plaintiff in this case is Otis Toussaint, and Sharito Lee, who you represent, is the defendant, correct?
That's correct.
And in this order, it says the parties will have joint legal and joint physical custody of the minor under number 2, correct?
Yes.
Subsequent to this order being entered, was there another order that at the time was entered in effect?
Yes.
And that order was in Tennessee, correct?
Correct.
In your representation, Ms. Lee, did you come to find out that the order was subsequently invalidated?
I did.
So I'm going to show you what's been admitted to States Exhibit number 2, which is the agreed order under docket number 17-JV-1085. Is this that agreed order I was talking about that was subsequently invalidated?
Yes.
In particular, are you aware of the circumstances in which this order was invalidated?
I am, yes.
Okay. And can you tell the jury how?
Yes. It was vacated by the Tennessee Court of Appeals.
And do you have an understanding of why?
I do.
And why was it vacated?
It was vacated because it was presented to the judge as an agreed order, meaning that both parties agreed to the order, and the judge signed it, and the Court of Appeals found that it was not a valid final order because both parties had not signed to demonstrate that they had agreed to it. It was presented to the judge as an agreed order, but the law required both signatures for it to be a valid agreed final order, so the Court of Appeals vacated it and said it was no effect.
So I'm gonna go back to State's Exhibit number 2. When you're talking about that both parties had not signed it, correct?
Right.
And it's fair to say on this agreed order under State's Exhibit number 2, that neither signature of the defendant or Ms. Goldenly is on this document.
That's correct.
Is it also? I'll show you what I'm sorry, what's been admitted in State's Exhibit number 3. In particular, are you familiar with this document?
I am.
Okay, and what is it?
That is the opinion that the Tennessee Court of Appeals made about the order that we just talked about.
So just kind of a history from here, just overall. The first order that was entered was in Missouri, correct?
Correct.
And are you aware of what year it was entered?
2010.
Go to the last page. On State's Exhibit number 1, it's fair to say that it went into effect on the 25th of January, 2021.
Yes.
2021, we have a Missouri order. And then in 2000,
So, excuse me, did I say 2021?
I'm sorry, 2011.
Okay.
I'm sorry. Apparently my caffeine hasn't kicked in. That State Exhibit number 2, the Tennessee order that was subsequently validated, that was entered on July 25th of 2017.
Yes.
And then in State's Exhibit number 3, we have the opinion from the Court of Appeals of Tennessee vacating that order, and that was filed on October 10th of 2019.
Correct.
It's particularly the language of the appeal. And the holding that they held that the juvenile court's July 2017 agreed order has no effective date of entry, cannot be relied upon as the basis of the father's contempt action. We vacate the July 2017 order and all subsequent orders related to the father's contempt action. So based on that, the 2017 Tennessee order was no longer in effect.
Correct.
And what order would be in effect at that time?
The Missouri order.
From 2011.
Yes.
In your representation of Ms. Goldenly here in your hearing, did Omari, I'm sorry, did Mr. TOUSSAINT, through his attorneys, acknowledge the validity of the 2011 Missouri order?
Yes.
And I'm going to show you what's been admitted as State's Exhibit number 5, which is under this Fayette County clause number 2019 CI 24180. And this is a letter on behalf of Mr. Toussaint to the court, I'm sorry, to the district clerk, correct?
Correct.
Has this been admitted?
Yes.
Okay.
And that it is a formal request to register an order under the Uniform Child Custody Jurisdiction and Enforcement Act, and then it includes a copy of the order. Correct? And what we see that's attached is that exact same 2011 order from Missouri.
Yes.
So as far as this letter is concerned, this was addressed to the court here in Bexar County on November 25th of 2019.
Yes.
So as of November 25th of 2019, the defendant has acknowledged that the Missouri order is the correct and enforceable order.
Yes.
Object to the leading, Your Honor.
All right, that's untimely.
I'll show you what's been admitted as State's Exhibit number 4, relating to a different cause over here in Bexar County under 2040 CI 24581. And this is who is this a filing by? Are you aware?
I can't look at that.
My
Is
approach,
it-
my approach.
Yes.
I believe that I got that. It is a filing by Mr. Toussaint.
In this document, I want particularly to look at number 3, which says parties order to be modified. Can you read where, starting where my finger starts, the order?
Sure. The order to be modified is entitled Judgment and Order and was rendered on January 25th, 2011 in the 19th Judicial Circuit Court of Polk County, Missouri, and cause number 10 AC-FC01450, styled Otis Earl George Toussaint versus Sharita R. Lee.
So in this filing, is Mr. Toussaint acknowledging validity of the 2011 Missouri order?
Yes.
In your experience as a family law attorney, why would somebody, what is the purpose of Mr. Toussaint petitioning the court here in Bexar County, asking them to enter the 2011 Missouri order?
I think that maybe it was exhibit 2, the letter that went to the clerk asking the court to register that Missouri order. In Texas, if you have an order, in this case about children, and you want to modify or change that order, you have to register it to the Texas court first. So you have to say, this is the order from some other state which controls our family, these kids. I need you to recognize it, find that it's a controlling order, and then we can proceed with a court case to make changes.
And to your knowledge and your representation of Ms. Rita Lee, has Mr. Toussaint or his attorneys ever alleged in any filing, if you're dealing with your attorneys, that the 2017 order was a valid order?
That it was a valid order?
Yeah.
Yes.
In what regard?
Both initially in terms of registering it, so that,
I'm sorry, the 2017 Tennessee order.
the 2016, sorry. The 2017 order, we call it the Montgomery County order, since there were issues in 2 counties in Tennessee. Yes, so there have been, like I said, 4 different lawsuits in Bexar County about this child, and in multiple of those proceedings, Mr. Toussaint and or his attorneys have, even though they've acknowledged that it's the Missouri order that's controlled, they say, but there was an agreed order in Montgomery County that provided we would do this, that, and the other. Even though the Court of Appeals vacated it in 2019, and even though in multiple proceedings and hearings in Bexar County after that, Mr. Toussaint has relied on the Missouri order being the controlling order.
And to your knowledge, has Mr. TOUSSAINT or his attorneys ever submitted to the court or asked the court to recognize officially the 2017 Tennessee order, Montgomery County order.
No,
So is it fair to say that through your entire representation of Ms. Lee, of Sharita, that every time you, that they petition the court that it's
Object to the lead,
concerning?
Your Honor.
All right, let me give a question first and then I'll answer your objection.
That is concerning the 2011 Missouri order.
on the issue of what order, what final order is controlling, yes, it is a 2011 order. Yes,
In your experience and practice as a family law attorney, is there a distinction between a order being vacated or voided versus voided?
it depends.
So if the order from Missouri would have said voided versus vacated, would that have a legal effect about its validity?
Gentlemen, object to the form of the question. I believe he's asking about a Missouri order, but I believe that the Tennessee Court of Appeals was the one that was vacating or voiding.
I thought it was the Tennessee.
You said Missouri.
Well, I was wrong.
All right, so if you'll re-ask your question and the objection will be sustained,
Thank you, Your
but
Honor.
ask your next question, please.
As it relates to the 2017 order, if the Court of Appeals in Tennessee had said that they voided versus vacated the 2017 order, would that have any distinction in the legal effect?
Yes, I mean, if it's voided, it was never proper, never proper under the law, as opposed to an order being vacated, right? But a case maybe being on appeal and an order may be vacated and sent back to the court for further orders or different orders, or different evidence. But in this case, the court voided and said it's just not a thing, it's not proper, it's not that, it needs some adjustment.
You know, object to that, it misstates the evidence.
All right, that'll be overruled.
I'm going to show you the conclusion, and it does say vacate. So states exhibit number 3. So it says we vacate the 2017 order and all subsequent orders related to the father's consent action. Would it have a different legal effect had it said we void the July 2017 order and all subsequent orders related to the father's consent action?
You mean with respect to 2011 order? Either way, it would be the 2011 order that would remain in effect.
As you are aware, were there any other orders in effect at this time?
No,
So the only other order that could be in effect would be the 2011 Missouri order.
yes.
So just so that we have kind of an understanding. Is it fair to say if
I'm going to object to writing in front of the jury. It's an unadmitted exhibit. Mr. Villarreal's essentially.
That'll be sustained.
you're saying 2011, we have a Missouri order,
Yes,
and then 2017, we have a vacated Tennessee order,
yes,
which was vacated by a opinion of the Court of Appeals of Tennessee at Nashville, and that was filed in 2019.
that's an information about, yes,
And then subsequent to that, in Bear County. We've had multiple filings in 2019 and 2021 from the defendant asking for courts in Bear County and in Texas to recognize the validity of the 2011 Missouri order.
Yes.
So as it relates to this case, in particular to on or about January 2nd of 2020, who was supposed to have custody of Omar?
Under the Missouri order, it would have been Miss Lee.
And that's in reviewing the order from Missouri as it relates to the possession of Omar and Toussaint.
Among other things, yes.
And prior to that, are you aware of the periods subsequent, previous to your representation when Sharita did not have possession of the child?
Yes.
And previous to that, were there periods of time, months or years that she did not have possession of her child?
Your Honor, I'm going to object based on the prior reasons I put forward to the court this morning.
Right, that'll be overruled.
Yes.
Okay, and we're talking about months, years?
Years.
And up until January 2nd of 2020, had Sharita had possession of her child during any period that year that you're aware of?
I don't believe so. I think there was one period of time where she was able to have possession for a day or two. And I don't know if that came after or before that January. But essentially, no.
So is it fair to say that the Missouri order was not being followed?
That is fair to say. I mean, in terms of time period,
I'll pass it, Mr.
All right, defense.
Thank you, Your Honor. Morning.
good morning.
Help me pronounce your last name.
Michelle.
Michoto. Morning, Ms. Michoto. I
Morning.
just have some questions for you.
Okay.
Just start off, you're a family law attorney, is that right?
Yes.
And as a family law attorney, one of the things that you've done in the past is you've enforced child custody orders, is that right?
I have.
And when you enforce a child custody order, tell the jury how that's done.
I think it's done in several ways. One way is under the Texas Family Code, they have some specific provisions that says if you have an order and the other party is not following it, you can file a suit with the court and advise the court of the specific dates and times that the order has been violated. Another way that you do that is by asking for a writ of habeas corpus and telling the judge we've got a valid order in effect. The other party's not following it. It's more of an emergency right now kind of proceeding, which is one of the things that we did in this case.
So
those are two examples.
okay, and let's talk about both of those examples are filed in civil district court. Is that right?
Yes, but not necessarily in the same case.
So you would file those, and maybe you'd file a new case, or sometimes if you're enforcing an order, but you'd file those issues in civil district court, correct? Yeah, yes or no?
Yes,
Okay. And a private attorney cannot file a criminal case. You'd agree with me, right?
yes,
But a private attorney can file an enforcement or a writ of habeas corpus, correct?
yes.
So January 2nd, 2020, had you filed an enforcement for Ms. Lee?
I don't believe that we represented her yet.
Okay. To your knowledge, had Ms. Lee filed an enforcement in Bear County, Texas?
She had made a filing. She made it pro se, so she made a filing and submitted to the court electronically the Tennessee orders asking for the child to be returned. She did what she thought she was enforcing and asking for contempt, but she was not represented by an attorney. So it was not under the letter of the law.
So there was no enforcement on file on January 2nd, 2020, correct?
No.
Okay.
Well, wait,
Okay.
I mean, I don't,
I asked you yes or no question, and so if they would like to redirect, they can do that. So January 2nd, 2020. And then you mentioned an enforcement. You'd have to specifically articulate how somebody violated a court order, correct?
in an enforcement proceeding,
Yes.
yes.
Let's talk a little bit about this 19th Judicial Circuit. Do you have it there in front of you?
I don't have any.
Yes.
This is State's Exhibit 1. Just look over your shoulder here.
Okay.
Just turn to that second page. Actually, we can do it on the, let's do it on the Elmo. Okay. So this court order. It says that Ms. Lee will have primary custody of Amari TOUSSAINT during the calendar school year. Is that correct?
Wait, which number are you on? Sorry.
I'm on number 3.
Yes,
Okay. What calendar school year are they talking
I'm not licensed in Missouri, so generally though, in Texas, and I believe also in Missouri, but not licensed there, is generally when a custody order refers to a calendar school year, it's the school that the child is enrolled in, or in the district in which the child lives, if they're not enrolled in that school, to young for school.
So, but you don't know, do you?
I don't know that.
You don't know which school year they're talking
I mean, I
about.
have to look at the order to see if there's a provision in there. I don't recall. I'm happy to do that, but based on that provision, a particular school is not identified now.
And they couldn't possibly know which school year they're talking about in 2020, correct? Because they don't know where the people will be living. Is that right?
They don't, but that's not how custody orders are drafted.
Well, what about this custody order
They're
that you've reviewed? How was it drafted?
even more vague in some respects than a Texas order.
Okay.
But a custody order is supposed to have enough flexibility so that it gets the kids and the parents through, the kids being 18. So it can't be, you must, although some orders aren't like this, you must live on this street, you must go to the school. Most orders are not that specific, but they are specific enough where it identifies the parent that gets to make that decision, then that's generally the school, school district.
And can you just go through this order and tell me where it says that?
Where it says what?
Where it says which school year is the one that's, which jurisdiction school year governs?
So it is of the type of order where it's the parent with whom the child lives. That's the child, where the child
And
is going to
where do you see that in the order?
school. That the child,
Just which paragraph?
that 3, that Sharita will have primary physical custody of Amari during the calendar school year.
But which school year? 'Cause I mean,
School year, every school year in 2018.
okay, but, so just generally, you understand that any ISD school year is different than Northside Independent school year, than Judson school year. All of those are different school years because they're different districts, correct?
I don't know, but sure.
Okay,
So it's, yes,
okay. So what jurisdiction school year applies? Is it Cole County, or is it the jurisdiction where the child is living? Which jurisdiction
It
applies,
is.
and where are you finding that in the order?
so it is because mom has the right to primary physical custody during the school year, she's the one making the decision about where the child goes to school. And that is the school calendar and vacation schedule that the parties follow where the child's going to school.
And so where do you see that in the order? What paragraph?
Well, all of that is not spelled out in this order.
So it does not say in the order what school year applies, correct?
What school year applies?
It could be where the child is living. It could be Cole County. It could be where Ms. Lee is residing. It doesn't say what school year applies, does it?
I don't understand the question.
Which,
When it says during the school year, setting a holiday schedule, you're saying because it doesn't identify a school, it could be wherever he's visiting at the time?
I'm saying that there's no way to tell. So school sometimes starts on January 2nd in some jurisdictions, correct?
Yeah,
And sometimes it starts on January 5th, correct?
correct.
Sometimes it starts on the first Monday
Yeah.
after New Year's, correct? I mean, every school district changes its holiday schedules. So, and I'm
I got
asking,
you. I mean, I can only tell you, having practiced family law for more than a decade.
and I'm asking you to look at the order. And
Yeah.
as parents.
All right, so
Again,
just
I'm
a
not
second, one
licensed.
second, time out. All right, everyone, Brenda can only take down one person at a time. So we're gonna have a question asked, the witness is gonna answer, and then we'll have another question asked, and then the witness will answer. But Brenda, I know she can do it, but we're not gonna make her do it. She's not taking down 2 people speaking at one time. So ask your next question, please.
So where in the order do you see how the parties are to know when to exchange the child after January 1st? Just give me the paragraph number in the order.
You're talking about not school now, but the exchange of the child.
I'm asking you, where in the order it tells the parents when they are to exchange the child after the new year?
On what date? This order does not say that.
Okay, so that order does not say when they should exchange the child after the new year, correct?
Correct.
Okay. Now, where are they supposed to exchange the children?
Under this order,
Yes,
just the one child. I think that the location in this order is somewhere in Missouri.
okay, so at the time, according to your representation of Ms. Lee, was she living in Missouri?
At the time of the order, yes, but not now. No.
Okay,
She moved
but
back to Tennessee.
January 2nd, 2020,
No, she was not living. in
she was
Missouri.
not living in Missouri.
Nobody was living in Missouri.
So to exchange the child according to the order, and you also know, based on your representation, that Otis was not living in Missouri, correct? So somebody from Texas and somebody in Sharita was living in Tennessee, correct?
Yes,
Okay, to follow the order would have to travel to Missouri, correct? To exchange the child.
sure, to follow it to the letter. That's not what they have been doing for years, since nobody lived in Missouri anymore.
Okay, so according to the order, they had to exchange the child in Missouri. Correct.
According to the language of the order, yes.
Okay, and so that wasn't practical for either party. You
No, they made an agreement to do something.
Let's talk about this Tennessee Court of Appeals order. And there's a difference. Let's just talk about courts generally, just so the jury can understand. What's the difference between a trial court and an appellate court? If you could just explain that to me.
Sure. So this is a trial court. That's where people come with their lawyers and they have a jury or a judge hear their case and make decisions, or where lawyers might bring their clients and get every order signed. And the appellate courts are where parties go if they feel like there's been a wrong decision in the trial court. So it's the kind of court where the judges sit up and listen to oral arguments, and then they decide whether or not what happened in the trial court was proper or improper.
Okay, and so in your experience, have you ever appealed cases to appellate courts?
I have.
Okay, and appellate courts don't hear parties directly. They review decisions of other courts. Is that right?
Mostly, yes.
Okay.
Yes,
Okay. So, and specifically for our purposes,
yes.
that's what was happening in this case. They were reviewing another order, correct?
The Tennessee Court of Appeals, yes, was reviewing the order from the Montgomery County Trial Court.
Okay. And the order that they were reviewing was an agreed order, correct?
It said agreed on it, but it was not agreed by Ms. Lee.
Okay. And that's your position, right?
That was her position.
And so
Yes.
we've used different words, invalidated, vacated, and voided, right?
Right.
Okay. I'm just going to ask you now, are those your words or the and so when we say that an order was invalidated, is that your word or is that the Tennessee Court of Appeals word?
I don't remember all of the words that the Tennessee Court of Appeals used. I don't know if it used the word invalidated. I know that.
Okay.
You have all.
Your Honor, can I approach the witness?
Yes.
I'm going to show you what's been. Whoop, just do it on the off. Okay. So this is the order. You'd agree? It's exhibit number 3. Okay.
Yep.
And this is the judgment, right? Okay.
Okay.
You'd agree with me? Okay. So this judgment is essentially it's a synopsis of the court's opinion. Would you agree with me on that?
I would agree that that's the first paragraph. Yes.
I couldn't.
Yes.
Okay. So where does it say the word invalidate in there?
It does not.
Okay. So it doesn't say the word invalidate at all. It says that it is affirmed in part, correct?
It does.
And it says that it's vacated in part.
It does.
Okay. And so I'm just going to turn the page a little bit. Now, does this court order, does that judgment, does it tell OTIS to do anything?
I don't remember. I'd have to look at it to see.
You're looking at it now.
Okay, but that's not the full opinion, so I would have to review the document to see.
But typically, Court of Appeals, do Court of Appeals tell parties to do things, or do they tell judges to do things?
They generally send a case back for a judge to make further orders. Yeah.
Okay. And so a Court of Appeals order, right, would tell a lower court judge to do something in accordance with the order. Is that right?
Often, yes.
Okay. And here, that's what happened, right? That they tell a Shelby court judge, right, that they should now do things. Is that right?
That is what part of the order. Yes, the part of the order is.
Okay.
Yes.
All right. And so this Court of Appeals is essentially saying, okay, we're affirming it in part, we're vacating it in part, and then for you all to figure it out, you need to go back to Shelby County. Is that right?
That's part of what they're saying. Yes.
Okay. And then let's take a look at this conclusion, which Mr. Villarreal had read before. Okay. Again, in that conclusion, do they use the word invalidate?
They don't.
Okay. Do they? And so that was your word. It wasn't the Court of Appeals word, correct?
I may have said validate. Yes.
I think you and Mr. Villarreal said it like 10 times, but that's not in the court. That's not in the opinion, right?
No, vacate is.
Vacates in the opinion.
Right.
Okay. And you mentioned before that the difference between a void order and a vacated order. Can you explain that to the jury? What's a
Yeah, I think I was misunderstanding his question in terms of a different legal issue, but clarified with respect to the 2011 order, the effect is the same, which is,
no, I'm not asking about the effect. I'm asking what's the
That's
difference
not-
between a void and a vacated order?
nothing relevant to the 2011 order.
Okay.
It's a different, it made a different legal basis for which the Court of Appeals makes a decision about why a purported order was improper.
Where does it say in this order that the 2011 Missouri order is now in place?
I can look at it and point you to the language, but when an appeals court vacates a trial court order, it goes away. It has no effect. It vacates it. Like it didn't exist,
But that's not what they did here. They vacated and affirmed, correct?
right? The
Okay.
part they affirmed was to send it back to Shelby County to make further order.
Go ahead and tell me where you see in that order that it's saying that the Missouri court order is now in effect.
That is the legal effect of vacating.
I'm asking you to find that in the order.
Well, they didn't use your words. I mean, I'm not gonna find words that you fit.
I'm asking you to find, not my words, I'm asking you to find in this Court of Appeals order where it says that the Missouri order is now in effect.
I don't know if it says those words.
Does
I can read it and
does
tell
it
you.
reference the Missouri order?
I don't remember. I'm happy to read it.
Does it reference it in the conclusion?
It's not referenced.
Okay, so instead, what it says is that it's, and let's look exactly at what is being vacated. Because the procedural history of this was that Mr. Toussaint had said that Sharita was in contempt, should be held in contempt for violating the agreed order. Correct?
Yes,
Okay.
that's what he said.
Okay, and so that's, and so after she was found to be in contempt, that's what she appealed up to the National Court of Appeals, correct?
I don't know if she appealed the contempt order so much as the underlying agreed order.
Okay, but she was arguing that that agreed order can't be the basis for contempt.
Yes,
Okay, And-
yes.
okay, and so the Court of Appeals says, right, let's take a look at it. That we vacate the July 2017 order and all other subsequent orders related to father's contempt action, correct?
Correct.
To his contempt action. Yes,
Yes,
okay. We affirm the juvenile court orders transfer of venue to Shelby County,
yes,
okay? This causes remanded to the juvenile court, right?
yes.
Okay, so they're saying that you've got to go back to juvenile court now, correct? To enter an order transferring venue to an appropriate court in Shelby County, Tennessee, right?
Yes,
And maintaining the status quo.
yes,
At that time, Omari was living with Otis, correct?
yes.
Okay, so he was living with Otis under that agreed order at that time.
Well, no, because at that time, the agreed order had been vacated, so it didn't exist.
As it applied to the contempt action. As it
Yes.
applied to the contempt action.
Yes,
Okay, so as it applied to the contempt action, it was vacated, correct?
as it applied, I'm sorry.
As it applied to the contempt action, it was vacated, correct?
The contempt action is vacated, yes. That's what
Okay.
you're asking.
Yes,
Yes,
all right. But the status quo was that Omari was living with Otis.
The status quo was the controlling order in effect.
But they don't say that the Missouri order is now controlling, do they?
No, they don't.
Okay.
They weren't asked to make an opinion about the 2011 order. They were making an opinion about the 2017 order, which
Instead,
superseded it.
they're saying that the status quo applies.
Yes.
And one of the reasons, and one of the
All right,
reasons,
so Brenna can only take down one person at a time. So I know that when we speak, we're used to these free-flowing conversations where everyone talks at the same time. But I'm looking as she's typing. Everyone's making it more difficult for her. So what we're gonna do is a question will be asked. You will answer the question. If anyone has an objection, they can raise an objection. I will respond to that. And then the next question will be asked. So I'm gonna ask that you all not talk over each other because Brenna cannot take that down and we need a record. All right, ask your next question.
so the Tennessee Court of Appeals does not specifically reinstate that Missouri order, correct?
It does by operation of how law works. It doesn't use the word, but that's the effect of the vacating of the 2017.
In that conclusion, it does not mention the Missouri order, does
It doesn't.
it? Okay. In that conclusion, it does mention that the status quo is supposed to be maintained, correct?
It does.
At that time, the status quo was that Omari was living with Otis, correct?
That is not the status quo that the Court of Appeals is referring to. But
Well, then why didn't they say that?
Why didn't they say that?
Why didn't they say that Omari could no longer live with Otis because the order was vacated?
Because as you point out, appeals courts don't give orders to parties in that way. They make rulings of law that affect orders. And so their ruling of law that the 2017 order doesn't exist at all means that the order still in
Okay,
effect
and so
is the Missouri order.
where does it say that the 2017 order doesn't exist at all? Where does it say that?
It's been vacated. So for purposes of
The contempt action,
and the custody order.
where does it say that? In the
all
conclusion,
that
where does it
order,
say that?
yes.
Where does it say that the custody order was
You don't
vacated?
have parties approach.
So where in that conclusion does it say that the custody orders were vacated?
We vacate the July 2017 order. The reference to the July 2017 order is that agreed custody order. We vacate the July 2017 order and all other subsequent orders related to father's contempt actions. It's talking about two different things.
That sentence, that first sentence, right? We hold that the juvenile court's 2017 agreed order has no effective date of entry and cannot be relied upon as a basis for father's contempt action. That's what it says.
That is correct.
Okay. It doesn't say cannot be relied upon for father's custody and father's contempt action, does it?
That's what it says in the second sentence. We
Okay, well, let's read the
vacate.
second. Let's-
That's what it means. We vacate.
Let's read what the second sentence says. We vacate the July 2017 order and all other subsequent orders related to father's contempt action. Okay, so the father's contempt action limits, right? It's essentially repeating itself. That it limits the July 2017 order, correct?
I don't understand the question.
Okay. we vacate the July 2017 order and all other subsequent orders related to father's contempt action. Again, it's talking about the contempt action, correct?
In the second half of the sentence, yes.
It does not then reinstate the Missouri order, correct?
By operation of law, it does,
Okay, and that's your opinion,
yes.
but it's not in the order. It's not in that conclusion.
It's not in the conclusion that it affirms the Missouri order. I agree.
Okay. And so then they affirm the juvenile court's order transferring the venue to Shelby County, correct?
Correct.
And this causes remanded to the juvenile court to enter an order transferring venue to an appropriate court in Shelby County, correct?
Correct.
And when did that happen?
I don't know. I don't know. You mean the transfer from Montgomery County to Shelby County?
Yes.
I don't know what the date was.
Okay. Had it happened on January 2nd, 2020?
Yes,
It had?
I believe so. I believe that the Montgomery County judge transferred the case and then it was appealed. So it affirmed the Montgomery County judge transferring it to Shelby County, but vacated the custody order.
So do you know where that order is? Where it would, when they took the order over to Shelby County, do you know where that is?
What do you mean?
Well, where is that order?
The Montgomery County judge made an order transferring it to Shelby County.
Yes, and how did it get, when did it get to Shelby County?
I don't know what the date was for that.
But
I think, so it's administrative, if that's what you're asking, when Ms. Lee found out about this order, she asked the Montgomery County judge to transfer the case to Shelby County where she lived. She also asked the judge to get rid of the custody order. He said, you have to appeal. I'll transfer it to Shelby County. She appealed, and so that stopped all the trial court action. Because the Montgomery County judge had already issued an order for it to go back to Shelby County.
and did she register it in Shelby County?
She had a motion pending, but the Tennessee judge did not do that. I don't know if the Tennessee judge did that.
So the Tennessee judge did not recognize Sharita's Missouri order, correct?
I wouldn't say that. I would say that it was not registered as part of a Shelby County custody proceeding.
But that's what what the Court of Appeals is asking someone to do, correct?
To register it.
Yes,
Um,
or to transfer it.
Yeah, it was transferred, so it was transferred. The Montgomery County judge said, yes, Ms. Lee, I agree with you, this case needs to be in Shelby County, where you live. Transfer it there, I'm not making any more orders about the custody part, you'll have to appeal that. She appealed it, and that stopped everything. And then the Court of Appeals said, this agreed custody order and his sanctioned motion to enforce it are all vacated. But we do affirm that the case should go back to where Ms. Lee lives in Shelby County. But by that time, Mr. TOUSSAINT had brought the child here.
So at the end of this, so the Court of Appeals essentially is telling a lower court to do something, correct?
Yes,
It's not telling Mr. TOUSSAINT to do anything, correct?
there are no orders, I don't believe, to Mr. TOUSSAINT and to either party in this order, in this opinion.
And you would agree with me that the Missouri order has become, so let's go back to handling your enforcements, correct?
I'm sorry.
When you do an enforcement in civil. Okay, so you filed enforcements in the past when a parent is violating a custody order, you can file an enforcement, right?
Yes,
Okay, and when you're filing the enforcement, you have to be specific, right?
yes,
And you have to serve the person personally, correct?
if you want to seek contempt, yes,
Okay, and so an enforcement can result in contempt of court. Is that right?
Yes,
And people can actually be put in jail for being in contempt of court, correct?
that is correct.
And all of that is handled on the civil side, right?
In a custody case, yes. There's both civil and criminal contempt, but that comes out of the district court, yes.
Okay, and that comes out of a civil court, correct?
Yes,
Okay, so all of those are civil issues, right? That can be resolved.
yes, there are causes of action that you're allowed to bring under the Texas Family Code to enforce orders.
And if, and so you were not representing Ms. Lee on January 2nd, 2020.
I don't believe that I was, no.
If somebody has an order from a different jurisdiction and somebody is violating that order here in Bexar County, you can file what's called a writ of habeas corpus, right?
Yeah, and we did, yes.
But not on January 2nd, 2020, correct?
I didn't represent.
Okay, but Ms. Lee had not filed a writ of habeas corpus on January 2nd.
I don't believe so.
And in that writ of habeas corpus, just give me a second. So she hadn't filed a writ on January 2nd of 2020. And as part of the writ, you can get what's called a writ of attachment, right?
That's one option, yes.
What is a writ of attachment?
And
the
at this
map-
point, I'm gonna object to the relevance of all these subsequent matters.
Sustained.
Josh, can I just have a second?
Yes.
So let's clear another thing up. There is a process by which a foreign order, and by I mean a foreign order, an order outside the state of Texas, there's a process by which you register that, correct?
Correct.
Okay. And you're familiar as a lawyer that all of family law has a process to it, correct?
Yes,
Okay. So if you file a petition for divorce, are you divorced?
you're not.
Okay. You have to go through the process of getting divorced, right?
Correct,
There's also a process for registering a foreign order, correct?
correct.
Okay, and what is that process?
You send the clerk a letter with a copy of the order that you claim is the valid order controlling and in effect regarding whatever the subject matter is, and ask the clerk here to recognize, to get a certified copy from the court out of which the order came. Send a letter to the clerk and say, this is the order that's in control, it's in effect, please register it here. And there's a notice period that generally it sits for a little bit, and then the clerk says, okay, we find that this is the controlling order in effect regarding these parties or these issues. And in a family law case, you have to do that because the court has to know what's in effect so that you can then modify the order. You have to know what the order is that you're supposed to change. So that's the first part of that process.
So there's a process to that.
Yeah.
Okay. And here we have dueling orders, correct?
No,
You have a Court of Appeals order, right?
an opinion, yes,
An opinion, and that opinion says to maintain the status quo.
yes,
And then you have a Missouri order from 2010, right?
yes.
And you'd agree with me that nobody is following that Missouri of 2010 order.
Right now, generally,
I'm not asking about right now.
well, I mean, at what point then?
January 2nd, 2020, no one's following that Missouri order.
On January 2nd, Mr. TOUSSAINT wasn't following the order. Ms. Lee wanted to.
Ms. Lee was showing up at the Missouri police station to exchange the child.
They had made a subsequent agreement not to exchange the child in the state within the order.
No, nobody was, it wasn't practical anymore to follow that order, correct?
To follow the exchange provision in a different state, correct?
There's also a question as to what school year would apply, correct?
I know, not a legitimate question.
So which school year, I mean, can you answer the question as to which school year applies?
It's the school year where the child should be living and
And
would be living if the order was being followed.
where in the order does it say?
It doesn't say those words.
That's again, that's your opinion as to what the order should say.
That's my opinion as to the legal effect of custody orders using this kind of language.
And when did Sharita register the Missouri order in Shelby County? Did you know the date?
I don't know. I don't know if it was. She had a motion pending to register it in Shelby County when the case went up for appeal. And so that also got stayed.
So the Court of Appeals opinion was never followed, correct?
I think the Court of Appeals opinion was followed. It was transferred to Shelby County and the other order had no effect.
When did Sharita, or when did that happen? What date did that happen? When was it transferred?
I don't know what date it transferred. The Montgomery County judge signed an order sending the case to Shelby County, leaving the 2017 custody order in effect. Sharita said, I'm appealing. And so the judge had signed the order to transfer it. It went up to the Court of Appeals. They said the custody order is vacated. The contempt action vacated. But we do affirm it needs to go back to Shelby County where Sharita lives. And in fact, then there was litigation in Shelby County. So I don't know the date the administrative transfer happened from Montgomery County to Shelby County, but the Montgomery County judge orders it.
So where does it say that the custody order is vacated? Where in that conclusion does it say?
We vacate the July 2017 order. That is the custody order.
And all other subsequent orders? And I guess there's a question. If all other subsequent orders is limiting a 2017 order.
I don't think that's a legitimate question if you read the opinion.
And then it says that they're maintaining the status quo. Correct?
Again, yes.
Okay. And at that point, the status quo was that Omari was living with Otis.
Your Honor, I'm gonna ask this whole line of questions we asked and answered.
Sustained.
When this order was written, was Omari living with Otis?
Yes.
No further questions. Your Honor.
State.
Just a couple of questions. Your Honor. May I use the.
Yes.
So we spent a lot of time talking about vacating the order, and particularly Mr. Locke wanted to spend time on conclusion. Is it fair to say there's other portions of this opinion that also provide context to what the court's intention was?
Yes.
So we go up to status. Because the July 2017 agreed order did not comply with Rule 58, it has no effective date of entry and is not a final judgment. Is that correct?
Correct.
What is, as both a lawyer and as a layperson, quite honestly, what does that mean to you?
I'm sorry, I wasn't gonna, that, you asked me again.
Yes, so that sentence up, because the July 2017 order did not comply with Rule 58, it has no effective date of entry and is not a final judgment. For both you as a lawyer and a layperson, what does that mean?
That means that it's as if the order never existed. It goes away.
It was never effective.
It's never effective.
So, going down here. I think Mr. Locke spent a lot of time going over this, but this I think pretty clears it up. Says, except for the juvenile court's order transferring the case to Shelby County, we vacate the July 2017 order and all subsequent orders relevant to the father's contempt action.
Right. I objected, that's not what it says.
I'm reading it from the document,
That'll be
It didn't say
overruled.
except.
right there. Pretty good at reading, so. Except for the juvenile court's order transferring the case to Shelby County, we vacate the July 2017 order and all subsequent orders relevant to the contempt action. Right?
Yes,
So to say the only thing that the Court of Appeals affirmed, which means gave the thumbs up, green light for, is transferring the case to Shelby County.
correct.
But says, again, we vacate the July 2017 order, that 2017 order being the 2017, what was titled agreed order.
Correct.
So going further down here. Says, my finger is. Right here, on remand and after transfer to an appropriate Shelby County court, mother and father can file any such motions she or he may deem necessary to address any issues in the custody proceeding relating to the father's petition to domesticate a foreign decree and to modify custody of the child. Correct?
Yes,
So there would, is it fair to say that there would have to be a foreign decree to domesticate?
yes,
Are there any other decrees relating to Omari Toussaint's possession and who should be have possession of him that existed?
no, and Mr. Toussaint had filed a motion in Tennessee to domesticate the Missouri orders. So not only did he ask Texas to do it, he also asked Tennessee.
So is it fair to say that this part of the opinion is referencing or alluding to the Missouri 2011 Missouri order?
Yes,
Mr. Locke made it a point to talk about vacating versus invalidating, use the word. Legally and semantically, do they really have a difference?
no,
And either way, is the 2017, as of the date of that opinion, in effect?
it was not.
And what order was in effect?
The 2011 Missouri order.
He also talked about, there's some criminal, I would say civil causes of action that Mr. Toussaint could have taken, or I'm sorry, Sharita could have taken in order to get custody of Omari. Does the ability to file a civil action prevent a criminal action? Right, so we see that in the context of somebody's killed, right? There might be a criminal murder case, but also a civil wrongful death case.
Right.
So by filing a wrongful death case, does it prevent the state from proceeding on criminal cases, on a criminal cause of action?
No.
We're talking about domestication of foreign orders. I'm not sure if I heard this correctly. Did you say that part of the purpose is so that that order can be modified?
Yes, so to be modified or enforced, right? Because Texas doesn't know that it, well, we don't know if that's a valid order or not, just somebody showing up with an order, so it's a process to validate, check, certify, what's the real order? It is a certified copy, file it, we'll bless it, and then you can go forward and do what you need to do, but we have to figure out what's the rule, what's the law for whatever the issue is, the parties are, and then once we know that's the good order, then we know what should be changed.
So in reference to Saints Exhibit number 5, which is on November 25th of 2019, what we previously talked about, Mr. TOUSSAINT and his lawyers asking for Texas to domesticate the Missouri order. Does that mean at the time that as when Mr. TOUSSAINT and his attorneys filed this, that the Missouri order had no effect?
No, it's the opposite. They're asking the Texas court to recognize that this is the order that is in effect, that is the controlling order about the child.
So when you file or asking or petition the court to domesticate a foreign order, does it kind of put everything on pause and then wait for Texas to decide what happens, or is it still an effective order?
An order remains in effect unless it is vacated, and then it has no effect. But an order that governs the party in family law instance, an order that governs the parties and the children remains in effect unless and until there's a new order. Might be a new order by an agreement, but either party could seek to enforce an order that is in effect. Probably not going to get far trying to enforce an order to do a custody exchange in a different state, right? But the party is entitled to bring an enforcement relative to the controlling order on any issue.
And as to your knowledge, was the 2011 Missouri order ever vacated, voided, invalidated? Or any other word that might mean the same thing?
Yeah.
So Mr. Locke spent some time talking about the specific provisions of the 2011 Missouri order.
Yes.
I should ask first, in your experience as a family law attorney, is it normal for an order to say specifically what school, district, or school that a child is attending?
It can, but generally, that is not the standard language. It's not standard language. Generally, that right is allocated to the parent to make that decision. And that's how it's addressed.
Right, I mean, it's pretty common sense to say if a kid's going to school, whatever that school calendar should be followed, right?
Yes, and in Texas, our orders generally have a provision that in school, obviously, where the child is going to school, or if they're not in school yet, or if they're known for with the parents that they live with that makes that decision, or where the should be really under the order.
So there are some specific periods of exchange though within this order on specific to a date, right?
Yes,
Specifically, I want to look at number number 17. Says it's ordered plaintiff. It was Sharita in this case, right?
no,
Oh, I'm sorry.
thank you,
That would be Mr. Toussaint, correct?
yes,
Is to have the minor child 10 weeks each summer, beginning June 1st and an end of August 1st, right?
right,
So that would be coincide with a summer, typically not within the school year.
correct.
Specifically, there's also other provisions to ensure that the parties can continue to follow the order, right?
Yes.
Specifically, I'm going to look at number 13. Says that is ordered that each parent will always keep the other informed of his or her address and telephone numbers and will notify the other parent within 24 hours of any changes. Right?
Correct.
And is it fair to say the purpose of that is so that one parent or the other parent can know where the other parent is residing, where the child may be?
Yes.
It's fair to say that didn't happen up until January 2nd of 2020.
Yes.
I'll pass it.
Defense?
So in May of 2020, were you representing Ms. Lee?
May of 2020. I believe so. It's definitely represented by June, I believe, but I think it'll be in May.
I'm just gonna. Which are on
Yes.
exhibits to the- I'm just gonna ask if you recognize this document. This is defendant's exhibit number 1. Do you recognize that?
I do.
Okay. And is this a document that?
Yes. Yes, I recognize it.
Okay, is this a document that you helped draft or,
Yes.
and it's actually an affidavit by Sharita, correct?
Correct.
All right, and so when I'd asked before about when Sharita had enrolled the Missouri order in Shelby County.
Right.
Do you remember that?
I do.
Okay, and you couldn't recall.
I don't know if Mrs. Judge ever registered the order under a motion from Sharita. So I don't know.
So, and
She had a motion pending to do that. And then he had his appeals. So that went on hold. And then when the first appeals opinion came out, Mr. Toussaint was to protect his child, and then the battle became where we're in the case now. The pending case in Tennessee just sat there while we got the emergency case.
and I was specifically asking, had the order been enrolled in Shelby County?
I don't know.
And you don't know, okay. And I'm just gonna refer you to paragraph 11 here. And this is again a document that you helped draft. It is an affidavit of Sharita Lee, is that correct?
It is.
Okay. Sharita Lee, yes, ma'am, I'm sorry. I'm just gonna refer you to paragraph 11 and see if that refreshes your recollection as to whether or not that order had been registered in January of 2020.
It doesn't refresh my recollection, but it doesn't refresh my recollection.
Okay, does-
I'm not remembering the fact that I know. I just don't know if it was ever, it doesn't help me remember.
do you believe that Sharita would lie in an affidavit that you helped draft?
No,
You cannot recall if the Missouri order was registered in Shelby County?
I don't know. She had a lawyer in Tennessee. I'm not licensed in Tennessee. I never went to native hearings there. I know that both parties asked the Tennessee court to register or enroll, or whatever the Tennessee word is. And the way things ultimately happened after much time, Texas took jurisdiction. And so I don't know if it was ever done by the Tennessee judge. I don't know.
In paragraph 11, she does address November November of 2019 to March of 2020, correct?
I'm sorry, in paragraph 11.
Yes.
Yes, I definitely do know that her motion asking the Tennessee court to enroll or register the order was not granted for a period of time.
And
I
that,
agree with that,
and that
yes.
period of time included January of 2020.
I don't remember. I mean, yes. Yes, I don't believe that by either party's order, the Tennessee judge identified January 2nd, but I don't know for sure.
And you would also agree with me that in the Tennessee order, they do not specifically say that the Missouri order is now controlled.
I agree, it doesn't use those words, but that's what it does by operation of law.
No further questions. Ron.
Just one really quick question. In your experience of representing Ms. Lee, Sharita, did you ever come into contact or come to find out who Otis Toussaint was? Did you ever see him?
Yes,
Okay. Do you see him here in the courtroom today?
I do.
And can you point at him and identify him by a piece of clothing?
He's sitting at the table on my left, wearing a dark tie in between this lawyer and woman in a red jacket, so we're.
Your Honor, may the record reflect that this witness is identified the defendant at this time. The same witness.
Any further
No
questions?
further questions.
All right, is this witness excused or subject to recall?
I would ask that she be excused.
Subject to recall, Judge.
All right, just make sure that the state is able, or the defense is able to get in touch with you if they want to recall you. The rule has been invoked. You're an attorney, of course, you know what that means, but you're not allowed to discuss your testimony with anyone. You're allowed to speak to attorneys for the state and attorneys for the defense. All right, thank you, Mr. Lashridge. All right, everyone, I'm going to give you all a short break. See, the deputy has informed me. I told you somebody would be able to tell me when you all needed a break. So let's take a short break. Will you all be able, if I give you till 11:15, is that enough time for everybody? All right, so before you go, you've heard some testimony in this case. You're not allowed to discuss anything that you've heard amongst yourselves or with anyone else. If, again, I don't expect this to be broadcast, but if you see it or someone wants to discuss it with you, let them know that you're not allowed to discuss it and just walk away. And make sure that you keep your juror badges on, because then people will recognize you in the courtroom and in the courthouse as jurors, and they won't be speaking with things around you, okay? All right, everyone, please rise for the jurors. right, everyone, please be seated. State, call your next witness.
Take calls Carlos Lopez.
Take a seat here, please. You can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you could take a seat and state your name for the record, please.
My name is Corporal Carlos D. Lopez Jr.
All right, state.
Thank you, Your Honor. Corporal Lopez, how are you employed?
I'm sorry, come again.
How are you employed?
I am a patrol corporal for the city of Selma Police Department.
And how long have you been with Selma Police Department?
A little over 5 years.
Prior to that, did you have any law enforcement experience?
I did.
I'm sorry,
I did.
and where was that?
I did about 6 years with the city of Animal Heights, and I did 2 years with the school district.
So, in all in total, how long have you been in law enforcement?
Almost 14 years.
As far as training and experience to become an officer, what does that look like?
To become an officer?
Yes.
Okay, so you gotta go to the academy in the very beginning. They can range anywhere between 5 months to 8 months to go on the academy. And then after that, you gotta have continuing education and take certain courses in order to keep your certification.
On January 1st of 2020, were you employed with Sutherland Police Department?
I was,
And were you on that day dispatched to an 8139 Ellerston Boulevard?
I was,
Is that located here in Fair County, Texas?
it is.
Do you recall the time that you were dispatched?
11 something PM, I can't remember exactly the time.
Would having a copy of your report help you refresh your memory?
It would.
Your Honor, may I approach?
Yes.
All right, Corporal Lopez, I'm going to show you what's been marked as State's Exhibit number 6 for identification purposes. You recognize this document.
I do.
Okay, and what do you recognize it to be?
My report.
And does it include, is it a whole case packet for Salem Police Department? You go here.
It looks like a printout of my report along with other officers' reports.
And again, would having a copy of your report help you refresh your memory? So what time you were dispatched?
Yes, it will.
So if you can just refer to it, but not read directly from it. If you could refer to your report, do you remember what time you were dispatched?
23:18 hours.
Okay, and for us that don't use 24 hours.
That is 11:18 PM.
So when you were dispatched, without specifically telling me what someone said, do you know why you were being dispatched?
Our dispatcher usually tells us why we're being dispatched to a call. And in this case, it was regarding a child custody.
And when you arrived at 8139 Ellerston, did you make contact with anybody?
Yes,
And who did you make contact with?
the reporting person, which is the person actually called dispatch.
Okay, and did you come to find out her name
I did.
and what is it?
Sharita Goldenly.
Okay.
I don't know if I said that right or not.
And when you spoke with her, generally, do you remember what her demeanor was like?
So I got there right after, I think it was Corporal Rodriguez that was there first. Usually when we respond to a call, if others are not busy, they usually go with us, like 1 or 2 officers at a time. So he got there first. He began speaking with her. Then, since I was dispatched to the call, I took primary. So I retrieved all the documents that she had provided him. So I had to she had to fill me in of what she had told him already. So with regard to her demeanor, she was concerned, I guess, for her child. What I found out after talking to her.
And you said that she provided Corporal Rodriguez some documentation that eventually was passed on to you.
That's right.
When you went to the location, did you make contact with anybody else?
No.
Did she tell you who specifically she was alleging had possession of her child?
She did.
And what did you come to find out that name?
OTIS, I can't pronounce the last name. Let me just try it.
Yeah, just give a good old try.
TOUSSAINT? Did I say that right?
Some people say TOUSSAINT, some people say
Okay.
TOUSSAINT.
I'm sorry.
Okay. Did you attempt to make contact with him?
I did.
How?
I've been knocking on the door, and I'd have to review the body camera. I don't know if it was a doorbell or not. I can't remember.
But you either knocked or rang a doorbell?
I did something in order to try to get somebody's attention at the residence.
Were you able to make contact with anybody in the residence?
No.
As far as after you speak with Sharita, ultimately at that location, you attempt to contact Mr. Toussaint. What do you do next?
She wished to file a offense report for the offense of interference with child custody. So in this case, we really don't do it on the street. We go back to our police department where we have the luxury to sit down and actually record the entire interaction in a room. And also where I can have all the paperwork ready for her to complete. And she could do it in a controlled environment.
So did that happen?
They did,
So you talked with her and you got her to fill out paperwork and you took a statement from her.
yes.
After you finished doing that part of your investigation, talking with Sharita, did you do anything else?
I completed my report.
At any point, did Mr. Toussaint or a lawyer or somebody representing him contact you?
Yes,
And did they tell you that they were Mr. Toussaint's lawyer?
they did.
And were you able to speak with him on the phone?
Yes, just to clear it, he contacted our dispatcher and we called him back. Because there's no direct line you can get me on.
And when you talked with his lawyer, was there anybody else present?
Yes, Sergeant Bettis was present and he actually took over the conversation at first. And I kind of just provided facts of the case as he communicated with the lawyer.
And was that interaction, was it in that phone call, at least in part, captured on body-worn camera?
It was.
Are you aware of whether you or your partner who was dispatched with you, whether either one of you were able to confirm at the residence that it was linked to Mr. Toussaint?
I have to review my video. I believe I ran the license plate, but I don't want to say that until I review my body camera.
Particularly though, in your report, it doesn't say anywhere that you ran the license plate. Is that fair to say?
It doesn't say that.
And you were dispatched with Corporal Rodriguez, correct?
That's correct.
And are you aware, based on Officer Rodriguez's report, if you could review it, would that refresh your memory as to whether you or he may have ran a license plate?
After reviewing the video, so I would be able to
If you reviewed his report.
review this report. You want me to go through it and read it right quick?
If you can just review it and see if it refreshes your memory.
Okay.
I'm going to object in reviewing somebody else's report.
I'll be on the roll.
You can review, just don't read it out loud.
So there was 2 Rodriguez's and I accidentally read the wrong one.
Okay.
Okay, after reviewing it refreshed my memory that we did run the license thing.
Okay, and did the license plate come back to Mr. Toussaint?
It did.
As far as when you talked with the attorney, I know you were dispatched at 11. At 11:18. When you were able to speak with the attorney, did that go into technically the next day, I'm sorry, the second?
It did.
So it was after midnight,
After that, yes.
but still within that same, let's say, night. Is that fair to say?
Still in the same shift, yes.
The documentation that Ms. Goldenly provided to you, do you recall what those items were?
That I recall, it was a quarter out of Tennessee.
If you could review your report and see if
Yes.
that helps you refresh your memory.
It was, I know there was 2 quarters that she provided. Yes, there was one from Missouri and then a Tennessee quarter as well.
Okay. And were you also provided a Tennessee Court of Appeals case?
Yes,
After reviewing all of those documents, based on you reading it, did you come to a conclusion about what was the valid order at the time?
I'm going to object to improper opinion evidence, Your Honor.
I'll be on the roll.
You can answer that question.
Judge, again, this is a lay witness. He's not been established as an expert.
Overrule.
Asking for a legal conclusion.
You can answer that question.
the question was, that
Can I get a ruling on my objection?
I said overrule.
Thank you, Your Honor.
You're welcome.
you can ask the question one more time, please.
After reviewing the Missouri order, the Tennessee order, and the Tennessee Court of Appeals order vacating the Tennessee order.
Right.
Were you able to determine, based on your opinion, what was the controlling order
I was
and which order was that?
the Missouri quarter case number. I don't know, maybe out case number.
No, that's okay. Yeah, I'll pass the witness.
All right, defense.
Thank you, Your Honor. Good morning. It's Corporal
Lopez.
Lopez. Thank you, Corporal Lopez. I just have a couple of real quick questions for you. We're talking about January 1st. That's New Year's Day, correct?
That is correct.
All right, New Year's Day 2020, correct?
2020, yes.
And an attorney representing Mr. Toussaint called you at approximately midnight on New Year's Day or January 2nd, 2020. Is that right?
That is correct.
An attorney called and you all spoke at midnight. And fair to say that's after normal office hours, correct?
Yes.
Okay. At 12 a.m. midnight, an attorney called you to discuss Mr. Toussaint's case. Is that right?
That is correct.
Okay. And you did not make an arrest that day, did you?
No, I did not.
You did not get a warrant for an arrest that day, did you?
No, I did not.
Okay. You didn't have enough information that day to get a warrant or to make an arrest on site, correct?
That's correct.
So the state asked you if you come to a conclusion about which order was controlling. You're not a lawyer, are
I am not.
you? Okay. And you read the Tennessee order, the Court of Appeals order, correct?
That's correct.
I think I wrote it.
And you read the Missouri order, correct?
That's correct.
Okay, and according to the Missouri order, just tell me, when is the exchange supposed to take place? If you could tell me. And just tell me what paragraph you're looking at.
Okay, so during this day, I guess paragraph number 14
Okay,
is going to be where she was actually making a complaint about. And you're asking when was the child supposed to be exchanged?
yeah, so in paragraph 14, where does it say Sharita's possession begins?
So that was the thing about this actual court order, is it doesn't specifically say at what time, which is in.
Okay,
Okay.
that answers my question. Thank you very much. Okay, and so what school year? Yeah, and I don't know if maybe you're aware that, what school district are you in? Mr. TOUSSAINT's school district. What school district is that?
Judson, I believe.
Okay, and Judson's school year, when does that begin? In 2020? Do you know?
I don't know.
Okay. Does it begin on January 2nd?
I don't know.
That's fair. So you didn't look to see Judson's school year. You didn't see when the Christmas break ended, did you?
No, I didn't.
Okay, and you didn't put that in your report anywhere?
I did not.
Okay. Now, I'm just going to ask you again, if I could approach the witness, Your Honor.
Yes.
And I had previously showed him State's Exhibit number 2. This is State's Exhibit number 3. Okay, is this the order that you reviewed, the Tennessee Court of Appeals order? Is that the order that you reviewed?
Yes.
And so I can approach the witness, Your Honor.
Yes.
I'm just gonna point you to the conclusion
Okay.
here. And at that time, essentially, Sharita was saying that Omari was living with Otis, correct?
That's correct.
Okay. And here, do you see this language here? It says this cause, and I'm going to put it up on the screen so we can all see it. This cause is remanded to the juvenile court to enter an order transferring venue to an appropriate court in Shelby County, Tennessee, and maintaining the status quo until the transfer is effective. Do you see that?
I do.
Okay. So in your investigation, when did the transfer become effective to Shelby County?
I'm confused.
I'm asking, you said that you had come to the conclusion that he was violating this order, but when did the transfer to Shelby County become effective?
So the conclusion I made was off of this order right here.
Okay, which doesn't specifically say when they should exchange the child.
Right.
And you did not investigate when the Christmas break ends in Judson ISD, correct?
That's right.
Okay, did you investigate when the Christmas break ends in Cole County, Missouri?
No.
Okay, did you investigate when the Christmas break ends in Shelby County, Tennessee?
No.
Okay, so you didn't look into that at all, did you?
I do not.
Okay, but you also mentioned that the Tennessee Court of Appeals, that you reviewed that order also.
I did.
Okay, and the status quo at that time, on January 2nd, 2020, the status quo was that Omari was living with Otis, correct?
Can you repeat the question?
On January 2nd, 2020, and when this order was written, the status quo was that Omari was living with Otis, correct?
When this one was written,
Yes.
that's right, yes.
Okay, and so when did the transfer to Shelby County become effective?
Your Honor, I'm gonna object to the relevance at this point.
They've opened the door.
Cumulative.
All right, so everyone again, we're gonna let everybody speak, one person at a time. And then I will make my ruling. So state, what is your objection?
I'm gonna object that to the relevance of when it was transferred. It doesn't have anything to do with what quarter was in effect at what time. And then I'm also gonna object to cumulative. We've gone over this, I don't know, probably 1,000 times with the previous witness, and now it's probably the third question on this.
All right,
this
that'll-
particular witness.
That'll be overruled.
So you see that line that says that the status quo is maintained until the transfer is effective.
I do.
When was the transfer effective? And if you don't know, that's fine. I'm just asking if that was part of your investigation.
Right, no, I don't.
So you don't know if Mr. TOUSSAINT was appropriately maintaining the status quo according to this Tennessee order, correct? You don't know.
That's correct.
No further questions, Your Honor.
All right, state.
No further questions. Your Honor.
All right, is this witness excused or subject for recall?
Excuse me, Your Honor.
Excused or subject for recall?
Sorry, excuse me.
All right, the rule has been invoked. What that means, you can't discuss your testimony with anyone. You are allowed to speak to attorneys for the state or defense. You understand?
I understand.
All right, thank you. You're excused.
Thank you.
State, call your next witness.
State calls Corporal Joe Rodriguez.
All right, you take a seat here, please. You raise your right hand. You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God.
I do.
All right, if you can take your seat and state your name for the record, please.
My name is Corporal Joe Anthony Rodriguez III.
All right, state.
Sorry.
Oh, usually when I say state, people will say Texas, but I'm referring to the state to proceed with their questioning.
Okay. I just woke up, so.
No problem.
Good morning, Corporal Rodriguez.
Good morning.
How are you?
Good, good, thank you.
Just for the record, can you give us your badge number?
Yes, it's 1336.
There was another Officer Rodriguez involved in this case, is that correct?
Yes,
And can you tell us who that was?
it's Justin Rodriguez. His badge number is 1365.
And can you tell the court how you're currently employed?
I'm currently a corporal with a daytime patrol ship with the city of Selma.
And how long have you been with the Selma Police Department?
July 2014. That's when I started.
And what sort of training did you have to become a corporal with the Selma Police Department?
I attended a law enforcement academy at San Antonio College back in 2007, where went to school for a year, took the state test, passed it, and then became employed with two other agencies prior to Selma Police Department.
And what other agencies did you work for?
The New Braunfels Police Department and the Universal City Police Department.
So what are your duties entail as a corporal with the Selma Police Department?
Do the same thing as a regular patrol officer, enforce state laws, traffic codes, investigate alleged crimes, basic patrol, deterrent patrol, security checks. As a supervisor, also oversee other officers. Make sure they're following the protocols and procedures of the Selma Police Department. Show up when needed.
So you oversee the patrol officers?
Yes.
And as part of your duties, are you ever called out to help with child custody issues?
From time to time.
And on January 1st, 2020, were you called out relating to any child custody issues?
Yes.
Approximately what time was that?
I believe it was around 11 in the evening.
And would it be helpful for you to see a copy of your report,
Yes, it would.
refreshing your memory?
Yes.
Okay. Okay, I'm showing you what's been marked as State's Exhibit 6 for identification purposes. Does that appear to be your report?
Yes, it is.
Now, you may review your report and refresh your memory, but please don't read directly from it.
Okay.
So around 11 p.m., where were you called out to?
The address was 8138 Elliston Boulevard.
And is that in Bear County, Texas?
Yes, it is.
And who did you make contact when you arrived at that location?
The complainant, Sharita Golden Lee.
And why were you called out to that location?
According to Ms. Golden Lee, she was at the location to try to get her son from the son's father.
And was anyone else there?
I believe her mother was.
Were any other officers there?
Yes, Corporal Lopez.
What did you do when you arrived at the location?
Met the complainant down the street from the address that I've given you. Spoke with the complainant. She advised that she had.
Judge, I'm going to object to the hearsay.
Sustained.
Without getting into what other people specifically said, what did you do?
Just started asking her details while we were there. It wasn't too long after that Corporal Lopez arrived on scene. He was the investigating officer and handed over the investigation to him.
And what was Miss Golden Lee's demeanor like when you were right here?
After reviewing a body cam, because it was 2 years ago, she seemed calm and collected. Believed that she seemed concerned, legitimately concerned. Driving from all the way to Tennessee to Selma to try to get her son, it led me to believe that she was concerned for her child.
And you said Officer Lopez arrived on scene and continued the investigation. Did you do anything else with regard to investigating information at the scene?
I did review the, well, body cam showed I reviewed the custody order that she had her in hand, but I don't recall what she had in it.
Did you guys attempt to make contact with the occupants of the residence?
Yes, we did.
And how did you do that?
We were located to the address, knocked on the door, I believe rang doorbell. We had no answer. Nobody answered from inside the house.
And who were you trying to make contact with?
The son's father, Mr. Otis TOUSSAINT, if I'm saying that correctly.
And were there any cars in the driveway?
There was I believe, a black SUV parked in the driveway.
Did you obtain any information about that car?
Yes, I ran the,
This is cumulative. I'm going to object.
That'll be overruled.
I ran the license plates of the vehicle through my dispatch, which they did, my dispatcher advised me that the registered owner was Mr. TOUSSAINT.
And the other officer Rodriguez, was he there with you guys that day?
No,
Are you aware if he went out there on a different day?
yes,
When did he go out?
I believe he went on the.
I'm going to object to outside this witness's knowledge.
Did you say- He says he knows he went out there.
All right, that'll be overruled.
I know I went on the first, another officer went on the second, and then once again on the third. I can't remember which day it was that he went. It was either the second or the third.
I'll pass the witness.
All right, defense.
Officer Rodriguez, is it officer, sergeant?
Corporal,
Corporal Rodriguez.
yes, sir.
You all didn't get an arrest warrant that day, did you?
No, we did not.
And you didn't make an arrest that day.
No.
I have no further questions for the witness.
All right, any other questions?
No, Your Honor.
Is this witness excused or subject to recall?
Excuse your honor.
Excused.
All right, the rule has been invoked. What that means is you can't discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state and attorneys for the defense.
I understand.
All right, thank you. Have a great rest of your day.
You too.
All right, everyone, I'm gonna give you all your lunch break. We're gonna be starting back up at 1:30, so I think that'll give you time to walk around to find a place for lunch. There's a cafeteria in the basement, and then there are other places throughout downtown within walking distance. You've heard some of the evidence in this case. You're not allowed to discuss or begin deliberation with anyone, with yourselves. You're not allowed to discuss anything that has happened so far. Does everyone understand? And do not look up anything. Do not seek to investigate anything. Do not look up any terms. All of the evidence that you will receive from this case will be inside this courtroom. Does everyone understand? All right, everyone, please rise for the jurors.